Hello everyone. I welcome you all for our today's lecture. I am Ankit Shrivastava, Assistant Professor of Law at RGNUL Patiala. The topic for our today's discussion is juvenile institutions in India. Before we go into the nuances of the subject, let's discuss about the introduction of the same. The history of juvenile detention facilities is an interesting area for our discussion. The most significant development in the juvenile justice system happened as a result of changes in family structure and its societal ramifications. The juvenile justice system was also supported by industrialization, urbanization, which helped elevate the cause of children. Probation, parole, juvenile courts, and adult prisons are only some of the many changes made to the criminal justice system in the previous century. All of these facilities placed a greater emphasis on rehabilitating and reforming the offender than punishing him, and their rules reflected this. Also, the criminological research of the time placed a premium on isolating the specific factors that led to criminal behavior and prescribing individualized solutions. This effectively ruled out any kind of standardization in how offenders were handled. There have been major ideological shifts in the juvenile justice system that led to its detachment from the larger criminal justice system. Because of this, criminologists and policymakers were also forced to rethink their assumptions about what drives criminal behavior. The long-held belief that the criminal behavior results from deliberate, free decisions by offenders has been disproven. To decrease an offender's moral accountability for his unlawful conduct and to place more emphasis on rehabilitating rather than punishing him, the progressive perspective placed greater emphasis on attributing criminal behavior to external circumstances. Serious criminological studies and research in conjunction with the medical profession, including psychology, pathology, diagnosis, and therapy, led to juvenile justice system being the only priority in rehabilitating juvenile offenders. To a lesser extent, the social sciences also contributed significantly to the improvement of juvenile justice system. The first real effort to divert juvenile offenders away from the adult criminal system and corrections system was the creation of a juvenile court. Juvenile offenders get specialized care in a locked facility. Juvenile courts, operating under the pretense of parents parentriate, have historically placed more focus on therapy, control, and monitoring rather than punishment. More leeway was given to the state in dealing with minor criminals. Now, after the introduction, let's go back and talk about the historical background with respect to the development of juvenile justice system. Now, when you look at the figure 1, it discusses the different prisons in India. Now, juvenile jail is also one of them, but the approach with the juvenile is a bit different. It is more of a youth detention center where minors or juveniles are kept with various facilities including child welfare and rehabilitation. So if you are under the age of 18 or 16 depending on the state, you get in trouble with the law, you will have to go through the juvenile justice system. Juvenile detention facilities have been around for just over a century. The law treats juveniles differently than adults, and the reason for the distinction vary from jurisdiction to jurisdiction. Researching the origins of the system's legal framework reveals that common law of England served as the model legal system across the world. Blackstone's commentaries on the laws of England was written by one of the most prominent English attorneys, Williams Blackstone and first appeared in the print in 1760. He determined who was legally considered a minor or an adult under the common law system. For him, there were two prerequisites for criminal liability. In order to commit a crime, two things must occur. The first one was that the offender must have the requisite malice to do so, and the offender must actually carry out the illegal act. As far as he was concerned, nothing could be considered a crime without these two elements. After outlining the basics of criminal responsibility, he noted that the first set of persons who lack the capacity to commit crime are newborns. He assumed that they were too young to completely comprehend the consequences of their behavior. Children under the age of 7 were deemed babies and so not legally culpable for any crime. But those aged 14 and above were held accountable for any criminal behavior. Furthermore, he argued that children aged 7 to 14 constituted a grey zone. He also believed that a youngster may be held responsible for his actions if the child learned right from wrong. For such a serious crime, he might face the death penalty if caught. Throughout the 19th century, trends in how juvenile were handled shifted. For troubled youth, social reformers and policy makers eventually established specialized institutions. Now, institutions were backed by reformers who hoped to keep young offenders safe by putting them in a different system from adult criminals. To aid the young offenders in avoiding further deviant behavior, they also emphasized a rehabilitation approach to discipline. In the beginning, juvenile courts relied on reform institutions with the primary goal of rehabilitation rather than punishment. Parens parentate, which literally translates to father of the nation, was the basis for all of these laws. Because of this idea, the state may act as a guardian over the minor. A casual, non-adversarial and adaptable attitude was stressed by the courts while dealing with juvenile issues, with an emphasis on doing what was in the child's best interest. Moving on. Now we have seen the introduction and historical aspects. Let's move on to the different types of juvenile institutions in India. Now, since its independence, a profusion of child protecting regulations and policies have been put into place in India. India ratified the UN Convention on the Rights of Child in December 1992, making it a member state. Since ratifying the convention, government authorities have been working hard to bring federal and state laws into compliance with its stipulations. Presently, the principal piece of law regulating juvenile justice and juvenile detention institutions in the Juvenile Justice Act of 2015. In an effort to implement global responses to the issue of juvenile justice, the JJ Act of 2000 and the JJ Act of 1986 sought to establish a similar law which preserved the rights and rehabilitation of juveniles and took into account their care, therapeutic interventions, restoration and advancement. Due to various changes in the global society and the subsequent rise in the visibility of juvenile engagement in criminal activity, more stringent legislation were required. In light of this need, the JJ Act 2015 was passed. After the advent of horrific Nirbhaya Delhi gang rape case in the year 2012, it shocked the whole country, as in this case one of the accused was less than 18 years of age, so it arose as question as to the age for offence in case the child is below 18 years of age and committed such an offence. The participation of a suspect who at the time of the argument was just 6 months away from becoming 18 was the primary cause and concern. To punish those responsible for this horrible act of rape, a new legislation in the year 2015 was passed. The act has superseded the previous juvenile laws and implemented significant reforms. A notable shift is the need that juveniles under the age of 16 to 18 be tried as adults. The Juvenile Justice Board, Child Welfare Committee, Open Shelter, Foster Care, Observation Homes, Special Homes, Children's Homes, Fit Facility, etc. are all examples of institutions and centers established under the Juvenile Justice Act of 2015 to care for children in need of rehabilitation. Now let's see all the different types of juvenile institutions in India. The first one being is the Juvenile Justice Board. Pursuant to Section 4 of the Act, the state government may establish a Juvenile Justice Board. The state government may establish one or more Juvenile Justice Boards for a district or group of districts specified in the notification for the purpose of exercising the powers conferred or imposed on such boards with respect to juvenile in conflict with the law. Now, let's see what is the composition of this Juvenile Justice Board that is established. As you can see in figure 2, I have established that what is the chart of the composition of the board. So, each board will have a bench made up of a chief metropolitan magistrate or a judicial magistrate of first class with at least 3 years of experience, as well as 2 social workers, one of whom must be a woman. Now, this bench will have the same authority as a metropolitan magistrate or a judicial magistrate of first class under the Code of Criminal Procedure 1973. A social worker's 7 years of experience in child health, education or welfare activities are required for membership on the board. Now, who can become the member of the board? Let's talk about the qualification. The magistrate is expected to have expertise in child psychology and or child welfare. A similar 7 years of experience is required for appointment as a member. The quorum. Now, for how long these members will be the part of the Juvenile Justice Board? The process pertaining to the board is discussed in Section 7 of the 2015 Act. It specifies that a child in conflict with the law be brought before board and that it is not required that a complete quorum be present at the time of child's production. What this implies is that a kid may be brought before a board member at any time, regardless of whether or not the board is in session. However, at the moment of final case disposition, at least 2 members, including the chief magistrate, should be present. If magistrate in charge disagrees with the majority, their decision will stand. Now let's talk about the different powers and functions of the Juvenile Justice Board. The board formed for a specific district shall have exclusive power to conduct and processes involving children within the district's area of jurisdiction as per Section 8 of the Act. When actions are filed before the High Court or Children's Court in accordance with Section 19 on appeal, revision or otherwise. Further, Section 8(3) specifically provides for the functions of the boards, and it includes: the board is responsible for ensuring that all minors and their legal guardians may participate fully and freely. The board must ensure that the child's rights are upheld. The board should make arrangement for the child to have access to legal help from a variety of different agencies. The board shall provide a translation or interpreter for the student. Board shall adjudicate and dispose of cases of children in conflict with law in accordance with the process of inquiry specified under Section 14. The board shall resolve the complaint and issue a final order that details the child's rehabilitation plan. The board is also required to examine the juvenile detention centers at least once each month. The board is obligated to provide a directive to the police to file a first information report. If the board discovers that a minor is being held in a facility designed for adults, they must immediately take steps to have the minor transferred to the observation home. Now moving on to our second institution, that is Child Welfare Committee. Now each district or several districts may have a Child Welfare Committee established within authority of section 27 under the Act. The state government is permitted to appoint one or more child welfare committees for each district for the purpose of carrying out the tasks and discharging the obligations placed before the commission. At least one member of the child welfare committee must be a woman, and another must have specialized knowledge in child welfare issues. The chairperson and members must have such credentials, and if in any situation a member of the committee has abused the authority given to him by this Act, it may revoke his appointment after an investigation. In its capacity as a magistrate's bench, the committee will have the same powers as a metropolitan magistrate, or as the case may be, a judicial magistrate of first class under the Code of Criminal Procedure 1973. The Child Welfare Committee's mission is to provide safety and support for disadvantaged children. Now this committee has been given a lot of powers. Now let's discuss the powers of this Child Welfare Committee. The Child Welfare Committee has been given the powers for the children's basic need and protection of the children's welfare overall. Now let's talk about the different functions and responsibility of a Child Welfare Committee. Now let's see one by one what are the different types of functions this committee performs. The committee shall be responsible for recognizing and accepting any child who is brought before it. The committee shall investigate any manner that might have an impact on the child's safety and well-being. The committee shall obtain a report on social conditions from the child welfare officers, probation officers, district child protection unit, or non-governmental organizations. The committee shall determine the person who is best suited for the care of the child. The committee shall make the decision in cases where a child has to be placed in foster care. The committee shall be under responsibility to assure the care, protection, and proper rehabilitation or restoration of the child. The committee is required to visit residential homes for abused and neglected children at least twice a month. The committee is under responsibility to make every attempt to reunite lost or abandoned children with their families. The committee is obliged with coordinating efforts between law enforcement, the Department of Labor, and other child welfare organizations. The committee shall investigate and instruct the police to report of child abuse at any child care establishment. Moving on to our next type of juvenile institution in India for the betterment of the child welfare, that is known as open shelter. Now I have put a picture of one of the open shelters which is there in India for your reference. Now any number of open shelters deemed necessary by the state government may be established and maintained either directly or via volunteer or non-governmental groups, and all such shelters must be registered as such in the way as may be prescribed under section 43 of the Act. The open shelter is a community-based program that will offer short-term residential care for abused and neglected children. Moving on to our next type of juvenile institutions in India is foster care. As per section 44 of the Act, children who are in need of care and protection may be placed in foster care. including group foster care by the committee in accordance with such procedure as may be prescribed in this regard, with a family other than the child's biological or adoptive parents, or with an unrelated family recognized as suitable by the state government. It further specifies that the foster family will be selected on the basis of family's motivation, skills, and background in child care. It also specifies that the foster family has to make sure that the kid getting a good education, healthy food, and enough medical care. The next type of our juvenile institution is observation homes. The state government is given the authority to operate observation houses under section 47 of the Act. Any state government may establish and maintain either independently or in cooperation with charitable organizations observation homes in each area or group of districts as may be required for the purpose of temporarily receiving, caring for, and rehabilitating any child in conflict with the law during the pendency of any inquiry. In addition, the Act states that the state government may, by rules made under the Act, manage observation homes, including their standards and services for juvenile rehabilitation and social integration. After taking into account the juvenile's physical and mental health as well as the seriousness of the crime, the child will be put in the receiving unit of the observation home. The creation of such surveillance houses is for the duration of any investigation into any youngsters in dispute with the law. Only juvenile offenders whose cases are currently being heard by a board are eligible to stay in observation houses. The next type of juvenile institution that we are going to talk today is special homes. The creation of therapeutic communities is addressed under section 48 of the Act. For the purpose of rehabilitating children who are in confrontation with the law, each district or group of districts might have their own unique house operated. The authority may also designate an institution other than a home as a special home under the Act if it believes it is suitable for receiving a juvenile in dispute with the law. The other small places or other juvenile institutions, small juvenile institutions which are functional in India, let's talk about the next one, that is the place of safety. A place of safety should be formed by the state government of a country for any person over 18 or any youngster in trouble with the law between 16 and 18 who has been accused or convicted for a major crime as per section 49. Furthermore, it mandates that the safe house offer distinct living quarters for children and adults who are under investigation and those who have been found guilty of a crime. The next is children's home. The state government has the authority to create the children's homes under section 50 of the law. The state may take the lead in establishing these homes for children, or it may partner with existing non-profits to do so. There may be one or several children's homes in a given area depending on whether or not the state chooses to build them. During the course of an investigation, the children's home may house and care for a youngster in need of protection, and delinquent youth can be shielded there. Now moving on to our next juvenile institution is FIT facility. It is a non-governmental organization which has been granted special status under any law in force, is suitable to temporarily care for a child under section 51 of the Act after conducting an investigation. So we have discussed various or numerous number of juvenile institutions in the country. Now let's conclude of whatever we have read today and what is for us in the future. Juvenile Justice Board, Child Welfare Committee, Open Shelter, Foster Care, Observation Homes, Special Homes, Children's Home, FIT facility, and transferring the child to an aftercare organization are all explored in the lecture with the main goal of the child's rehabilitation and social integration in mind. The goal is to get the family life back to normal and to help the kids regain their sense of pride and self-esteem. Each and every child in the country has a right to the resources the Republic provides in order to grow up healthy, happy, and whole. Child development is analogous to plant development. Just as a plant needs protection, promotion, substance, and the right atmosphere to grow into a large fruit-bearing tree, so too does a child require these things in order to mature into a responsible and productive adult. Children are the country's future. Thus, proper care and training for them is a national priority. Determining the causes of juvenile delinquency and developing a plan to stop it by addressing those causes is an immediate priority. The state must be prepared to deal with such situations. Thus, it must have a strategy in place to ensure that these children get the necessities. Delinquency may be reduced by careful planning of preventive measures. In order to fulfill the rising demand and reduce the prevalence of criminal activity, it is necessary to employ a sufficient number of well-qualified personnel. So with this, students, we come to the end of our today's lecture. Thank you very much.